Welcome to the deep dive. Look, if you've ever bought a house or taken out a mortgage, you know about the sheer volume of legal stuff involved. It's a lot.
It really is mountains of paperwork.
Exactly. So today, we're aiming to give you a kind of shortcut, a way to grasp the essentials, those first legal steps when you buy property in England and Wales.
Yeah, cutting through the jargon.
We're going to tackle things like title searches, covenants, easements, all that dense language. Really trying to answer two big questions for you. How is your ownership actually guaranteed? And, maybe more intriguingly, what hidden rules might stick with your land forever?
And that confusion, over the legal terms, that's precisely why we're doing this. We want to make the sort of nuts and bolts of conveyancing much clearer.
Okay.
We'll cover three main things. First, the absolute foundation, land registration, how the state guarantees it. Second, why lenders care so much about the official quality of your title.
Right, the different types of title.
Exactly. And finally, we'll unpack those legal obligations, some ancient, some modern, that affect pretty much every property. The things that dictate what you can and sometimes can't do with it.
Okay, makes sense. So let's start right there at that foundation, how ownership actually gets recorded officially.
Sounds good.
The system we have now, it's heavily shaped by the Land Registration Act 2002, although there were earlier laws going way back. But 2002 was the big one.
Yeah, a huge overhaul. It replaced the old 1925 Act. And a key aim, really, was to smooth the path for electronic conveyancing, bringing it all into the digital age.
So what's the goal? Is it just like keeping a big list of who owns what?
It's much more ambitious than that, actually. The state's aim isn't just to keep a record, but an accurate, up-to-date, and continuing one.
Continuing, meaning?
Meaning it reflects changes over time reliably. And by doing this, the state can actually guarantee the title's validity. If you buy registered land, the odds of someone else successfully claiming it are, drastically lower.
Okay, so
Security, yes. And it also acts as a big flashing signpost. It alerts potential buyers, lenders, everyone involved to any existing rights or burdens tied to that specific piece of land.
Now, not all land is in this system yet, is it? I mean, registration only became compulsory relatively recently in 1990 and only for certain situations.
That's right. There's still unregistered land out there. It only has to be registered when one of three specific trigger events happens.
And what are those triggers? What forces land onto the register?
Okay, the three big ones are, first, when the land is transferred, bought and sold, essentially. Second, when a lease of more than 7 years is granted over it.
Right.
And third, when a legal mortgage is created upon it. That last one's key. The moment a bank lends money against the land, boom, it has to be registered into the official system.
Got it. So once it is registered, all the key details get organized. You mentioned the registers. It's like 3 different files for each property.
Yeah, that's a pretty good way to think about it. 3 distinct sections, all under one title number. If you, the listener, look at your own title documents, you'll likely see these.
So what's in each file?
Okay, let's break it down. Think of them as different views of the property. First up is the property register.
Okay.
This is like the map and description. It identifies the land, gives the official title number, and importantly, lists any rights that benefit the property, like a right-of-way you might have over a neighbor's land.
Makes sense. What's next?
Second is the proprietorship register. Think of this as the owner's ID. It names the current owner, says when they were registered, and crucially states the class of title. We'll get to that in a moment. It also lists any restrictions on the owner's power to sell or mortgage.
Okay, owner details and their powers.
Yeah.
And the third one, you mentioned this is the one banks really focus on.
Yes, the charges register. This is where, you could say, the bad news lives.
Uh-oh.
Well, maybe not bad, but it's where all the liens and liabilities are recorded. Things like the mortgage itself, the lender's rights, but also other critical stuff like restrictive covenants, negative easements, and even things like a non-owning spouse's rights if they've been formally registered under family law.
So any financial claim or restriction on the property, it should be listed there.
Generally, yes. That's its main purpose. Transparency about burdens.
That brings us neatly to the idea of title quality. You mentioned the proprietorship register shows the class of title. Why are there different classes, and why does it matter so much if I'm trying to get a mortgage?
It matters fundamentally because it reflects risk. The best possible title, the absolute gold standard, is called absolute title.
Absolute. Sounds pretty definite.
It is. It means the land registry is fully satisfied that the ownership is clear and sound. This is what every lender wants to see, especially for freehold property or very long leases.
Okay, so that's the ideal. What if the title isn't quite that perfect?
Then you move down the hierarchy. Next, is good leasehold title. You see this with leases, obviously. It means the lease itself seems fine, but there might be some question mark over the landlord's own title, the freehold title. Or perhaps the freeholder couldn't prove their own absolute title when the lease was first granted.
So still generally okay, but a slight maybe uncertainty about the ultimate landlord.
Sort of, yes.
All right.
Lenders will usually still proceed, but it's noted it's not quite as clean as absolute.
Then we get to possessory title. This sounds, well, weaker, like maybe the paperwork is missing.
That's exactly the context. Possessory title is often granted when the person applying for registration simply can't produce the historical title deeds. Maybe they were lost, destroyed, things happen, like during wartime bombings, deeds literally went up in smoke.
Wow, okay.
So the current owner is registered, but, and this is the key bit, that registration doesn't protect them against someone popping up later with a stronger, older claim that existed before the land was first registered with possessory title.
Right. So if I'm the bank being asked to lend against a property with only possessory title, I'd be nervous. What's a practical fix?
You'd be very nervous because your security, your mortgage, could potentially be challenged. That's why lenders almost always insist on indemnity insurance in these cases.
Insurance.
Yes. It's an insurance policy that covers the lender, and often the owner too, against the financial loss if that theoretical older claim does actually emerge and succeed. It plugs the gap in the guarantee.
And there's one more. Qualified title.
Yes, qualified title. It's quite rare. It means there's a specific known defect mentioned on the register that prevents it being absolute or good leasehold. The registry basically says it's good except for this one particular issue.
Okay, quite specific then. Now, moving from slightly shaky paperwork to, well, no paperwork at all.
Right.
Let's talk about adverse possession, commonly known as squatters' rights. How does this work? Can someone really just take land?
Well, it's more complex than just taking it. But yes, under certain conditions, long-term occupation can lead to ownership. The rules changed significantly with the 2002 Act, and crucially, they differ depending on whether the land is registered or unregistered.
How so?
For unregistered land, the old rules largely apply. If someone occupies the land openly, without the owner's permission, and acts like the owner for 12 continuous years, and the true owner doesn't object or interrupt them,
12 years.
12 years, yes, then the squatter can usually apply to be registered as the owner, typically with absolute title.
But what about registered land, where the owner is clearly named on that digital record we talked about? Surely it's harder then.
Much harder. The time frame is shorter, 10 years of occupation, but the process is different. The squatter applies to the Land Registry. The registry then must notify the registered owner.
So the owner gets a warning.
Exactly. If the registered owner objects within a specific time frame, the application is generally rejected. Full stop. The system is designed to protect the registered owner.
But are there exceptions? When might the squatter still succeed, even if the owner objects?
There are a few narrow exceptions, like boundary disputes where the squatter genuinely and reasonably believed the land was theirs for those 10 years. But generally, for registered land, objection stops the claim. If the owner doesn't object, though, after being notified, then the applicant can be registered as the new owner.
So it balances the register's integrity against perhaps the reality of who's actually using the land.
Precisely. It tries to strike a balance.
Now, before we move off registration, we absolutely have to stress that point about the deadline for first registration of unregistered land.
Oh, yes. This is critical. If you buy a piece of unregistered land, the transfer triggers compulsory registration. You, the buyer, have just 2 months from the date of transfer to apply to the Land Registry.
2 months. That sounds tight. What happens if you miss it?
Disaster, potentially. If you miss that 2-month window, the legal ownership doesn't actually pass to you. It technically reverts back to the seller, who holds it on a sort of trust for you.
So you've paid, but you don't legally own it.
Not in the full sense, no. It creates a massive legal mess. You'd find it incredibly difficult, maybe impossible, to sell it on or get a mortgage later. It's a deadline you absolutely cannot miss.
A 2-month window to secure your actual ownership. Yeah, definitely one to remember. Okay, let's shift gears now. We've talked about getting ownership recorded.
Yeah.
What about the invisible strings that come attached? The rights and obligations that, as you say, run with the land.
Yes, Section 5.3 in the source material deals with this. These are things that bind future owners, not just the person who first agreed to them. They stick to the land itself.
And the first big category here is easements. What exactly is an easement?
Okay, think of it as a specific limited right that one property has over another, usually neighboring property. There has to be what we call a dominant tenement, the property that benefits from the right, and a servient tenement, the property that carries the burden of the right.
Two properties involved. Got
Yeah.
it.
And the right has to actually benefit the land of the dominant tenement, not just provide a personal or commercial advantage to the owner.
Right. And they come in two main types, positive and negative.
Exactly. Positive easements give the owner of the dominant land the right to do something on the servient land. The classic example is a right of way, the right to walk or drive across your neighbor's land to get to your own.
Okay, actively doing something. So negative is the opposite.
Yes. Negative easements give the owner of the dominant land the right to prevent the owner of the servient land from doing something on their own property. The best known example is the right of light.
Right of light, how does that work?
If your building has received natural light through specific windows for a long time, typically 20 years, you might acquire a right of light. This means your neighbor can't build something that would significantly block that light. It can seriously impact development plans.
Interesting. So these rights, can they last forever
Mm.
or do they disappear?
They can potentially last forever, but they can also be extinguished. The obvious way is if the same person comes to own both the dominant and servient properties, you can't have an easement over your own land.
Makes sense.
They can also be formally released by deed. Or, and this is important practically, they can be lost through implied release or abandonment if the right hasn't been used for a very long time, say 20 years or more. The law assumes you've given it up.
Okay, so that's easements rights over other land. What about covenants? These often sound similar, like restrictions.
They are similar in effect sometimes, but they arise differently. Covenants are essentially promises made in a deed, usually when land is sold, often imposed by a developer selling plots on a new estate, for example, to maintain standards.
Promises in a deed. And like easements, they can restrict what you do.
Yes, particularly restrictive covenants. These are the you must not do this promises. And the key thing here is that restrictive covenants do run with the land, meaning they bind future owners automatically, provided they're registered correctly on the charges register.
Okay, so they stick. What are some common examples?
Oh, you see them all the time on newer estates. Things like, do not build an extension without the developer's consent. Do not park caravans or commercial vehicles where they can be seen from the road. Do not convert the front garden into a driveway. Do not let the external paintwork fall into disrepair. Things that maintain the look and feel of the area.
Right, protecting the developer's vision or the neighbor's amenity. Now, what about the other side of the coin? The you must do this promises. Positive covenants. Things like maintaining a shared fence.
Now this is where it gets legally quite different and, frankly, a bit tricky.
How so?
Under English property law, the burden of a positive covenant, the obligation to actually do something, especially something that costs money, like repairing a fence, does not automatically run with the land to bind future owners.
Wait, really? So if the deed says the owner must maintain the boundary fence, the next person who buys the house isn't automatically bound by that?
Not automatically, no. The benefit can run, but the burden generally doesn't pass with the land itself in the same way a restrictive covenant does.
So, how do developers or neighbors enforce things like fence maintenance then?
There are workarounds. The most common is a chain of indemnity or a specific clause in the transfer deed. The original seller makes the first buyer promise that they will maintain the fence and that they will impose the exact same promise on anyone they sell to in the future.
So it's like a personal promise that gets passed down the chain each time the property sells.
Precisely. It relies on each owner making the next owner promise. If that chain gets broken, if someone forgets to put the clause in a future sale, then the obligation can effectively disappear for subsequent owners. It's not attached to the land in the same fundamental way.
That seems complicated.
It is, and that complexity is why sometimes you see other arrangements like management companies, or why lenders often prefer the certainty of restrictive covenants over positive ones. The enforcement is just much more straightforward.
Fascinating distinction. Okay, we've covered modern registration, titles, easements, covenants. But now, for something completely different, a real blast from the past hiding in property law. Chancel repair liability.
Yes. This is a truly bizarre and, for some unfortunate owners, incredibly expensive historical hangover.
Tell us about it. Where does it come from?
It dates back centuries. to the medieval era and the system of tithes. Historically, certain parcels of land were owned by the local parish church, and the owners or tenants of that land were responsible for maintaining the chancel of the church. That's the bit around the altar.
Okay, back when the church owned lots of land.
Exactly. But when much of that land was sold off or privatized over the centuries, that obligation to repair the chancel sometimes remained attached to the land itself, even as it passed into private ownership.
So someone buying a regular house today might unknowingly inherit a medieval duty to pay for church roof repairs.
Potentially, yes. It depends on whether their specific property sits on land that historically carried this burden. And the sums involved can be staggering. The notorious case is the Wallbank case from 2003.
What happened there?
Mr. and Mrs. Wallbank owned a farmhouse. They received a demand from their local parochial church council, the PCC, for almost £100,000 to repair the church chancel.
Wow, £100,000.
And it got worse. They fought it through the courts, arguing the liability was unfair or didn't apply. They lost. By the end, their total bill, including the church's repair costs and all the legal fees on both sides, was estimated at over £350,000.
That's terrifying. Just from owning a piece of land with this hidden history.
Absolutely. It sent shockwaves through the conveyancing world and proved this ancient liability was very much alive and enforceable.
So what's been done to stop people getting these horrific surprise bills now? Is there more protection?
Yes. Thankfully, the law changed in 2013. Since October 13th, 2013, PCCs have had to take steps to protect their right to claim chancel repair costs if they want it to bind future buyers for value.
What's that?
If the property affected is registered land, the PCC must register a notice of the liability on the charges register, that third register we talked about. So it will show up clearly on a title search.
Okay, so it's visible now for registered land.
Yes. If the land is unregistered, the PCC has to lodge something called a caution against first registration. This acts as a tripwire, so when the property eventually does get registered for the first time, like when it's next sold, the liability will be noted then.
But what about properties that haven't been sold since before October 2013? Could the liability still exist, even if it's not showing on the register yet?
That's the potential gap, yes. If a property hasn't changed hands for value since that date, an unregistered liability could still theoretically exist and bite a future purchaser, although the PCC would now have to register it to enforce it against them. It's why conveyancers still check, and why chancel repair insurance is often recommended.
Insurance again. Seems like a common theme for these hidden risks.
It is. You can get insurance against the risk of an unknown liability emerging after you buy, which is usually quite cheap. Or if a known potential liability is identified, you can sometimes get insurance for that too, though it's obviously much more expensive. It's all about managing that residual risk.
Okay, what a journey. We've gone from digital registers right back to medieval tithes. This deep dive really shows property law isn't simple, is it? It's this incredible mix of modern rules and ancient obligations.
Absolutely.
So for you, the listener, maybe the key things to take away are, first, that title quality absolute versus possessory really matters, especially for your mortgage. Second, almost every piece of land comes with some strings attached, whether it's an obvious building restriction or a potentially obscure historical liability.
And understanding these layers, these registered interests and potential hidden issues is really what transforms buying bricks and mortar into securing a genuinely safe and valuable asset. It highlights why that detailed search and investigation by your conveyancer is so absolutely vital. They're navigating this complex landscape for you.
Definitely. Okay, let's end with a final thought, something to maybe chew on. We talked about adverse possession squatters' rights, where practical occupations can, after 10 or 12 years, actually override formal documented ownership. It makes you wonder, what does the law ultimately value more? The sanctity of the paper trail, the meticulously kept register, or the brute fact of someone actually using and possessing the land day in, day out? Which principle holds more weight in the end?